Hello aspirants, I'm Indumati Karthikeyan from InKar IAS Academy. Today we are going to see about the 11th December current affairs. This topic comes under the editorial, the topic taken from the Delhi edition, that is SAMBHAL and the peril of the judicial evasion. This topic comes under our GS1, communalism, and also there is a GS2, separation of powers between various organ dispute redressal mechanism. First of all, the court order shows once again the reluctance and adjudicate the core issue that ought to be have been assertive stand on the validity of the place of worship Special Power Act. That is a paper 2005, the judicial inactivism. That is a chart M. Old Father that talks about the court due to decide of adjudicative duty. He explains how judicial inaction can have consequences that every bit of the significant as resulting in the judicial action. According to him, the judicial failure to meet the minimum requirement and role likely to more difficult to detect than action going beyond the proper limitation. So, and therefore, there is a judicial activism. Judicial inactivism is in a way more worrisome. That there's another case, judicial deferment, that is the approach adopted by the Supreme Court of India in the SAMBHAL Masjid case, that is in Uttar Pradesh, in yet another instance of judicial deferment. And also there is a refusal to take stand. The court has refused to take an emphatic stand in the capable of giving a final answer. They are not giving final answer for this issue. And also there is a court order to freeze this in this civil court. So this is the different way of approach that the proceeding based on the survey conducted at the mosque and relegated petitioner, the SAMBHAL Shai Jamma Masjid Committee to the Allahabad High Court for a decision. So there is a legal remedies and peace is required, but the court also indicated that legal remedies for petitioner and requested the parties to maintain the peace and harmony. And also there is a temporary relief for the minority groups because there is a no tension created on account of survey ordered by the local civil court and also which led to a loss of human lives. This is a major concern. So minority groups reactions will be the order was also one welcome one to certain minority groups to avoid this kind of violence. And also there is a perils of judicial evasion, that is a judicial evasion. The perils, such a gesture of judicial evasion in India cannot be lost sight on it. So and also there is a historical precedence that is a demonstrated the country recent history. And also there is a failure to honor the legislation in a way. SAMBHAL episode itself a result of the judicial failure to honor the relevant parliamentary legislature. And also it is very much important that it is a failure to resolve given the fact that place of worship Special Power Act 1991 has been breached by some courts in India and the Supreme Court itself, and the challenge against the act has been kept pending before the court of years. It is essential to take an introspective and also retrospective approach to the issue and also upcoming hearing. There is a Place of Worship Act 1991 which states that section 3 that prevents conversion of places of worship from one religion to another sector, another religion. And also in the section 4, that is a section 4 having two sections, that is section 4 of 1 that declares the religious character of the place of worship existing on the 15th day of August 1947, that is the Independence Day, shall continue to be the same. And also there is a section 4 of 2 that is further clarifies that the suit proceeding will respect to the religion any place of worship existing on the 15th August 1947 cannot be initiated or continued in the Court of India after the promulgation of the Act. And also there is an exception of dispute. The Act exempted for the Ram Janmabhoomi and also Babri Masjid issues. So and also there is a punishment, most significantly the contravention of the provision and also initiation and also continuation of the proceeding. It is a punishable offense. And also as per the section of 6 of the act, the sentence would be a jail term for the 3 years, so apart from the fine. So there is a legislation intent behind this act. There's a purpose of the act mainly due to the country's history thought the promulgate the act was well orchestrated game plan designed by the communal outfit to dig the past and to the evoke religious sentiment and also for the political gain in incremental way, and also there is a court role should have tried to peripherals remedies and also perpetuated the uncertainties in the litigation, and also there is a over judicial posture on the validity of the act. It's clearly a overdue. Earlier cases, first of all, the earlier cases, judicial deferment, the court has often restored that jurisprudence of deferment on earlier occasion too, and also Shaheen Bagh protest, that is a jurist that protest, that Shaheen Bagh protest, and in Delhi there is a citizenship act of CAA. The court formed a committee to the protester to try to arrive a settlement in the Apit Sani and also Commissioner of Police, and also there is a farm laws that in Rakesh Vaishnav versus Union of India, when the contentious farm laws were questioned by farmers in the street, and also the court constituted expert committee to negotiate between the farmers' bodies, and also there is a center to create a congenial atmosphere and also improve the atmosphere. So there is a inaction on farm laws. The court also could not decide the validity of the amendment till date, and also the remains volatile. The farm laws were repealed essentially because the people protest and not by negotiation. There is a reluctance in the SAMBHAL Masjid case. That is a reluctance, or there is an order to stop court on the SAMBHAL Masjid issue shows an exactly similar reluctance to the adjudicate of the core issue, and also there is a failure to uphold the 1991 Act. It's a convincing reason to the court for not upholding validity of 1991 Act, since the enactment demonstrates constitutional values and such as fraternity and secularism since the laudable object preserving the nation's social religious fabric. So these again this is challenge against the statute of there is a entertained by the court, and also there is a constitutional support. That the support may be a inclination to admit such places, at least reject the term and point of time to support the constitution bench judgment in the Ayodhya case. There is a further in the Ayodhya case judgment implication. The Ayodhya judgment is a true court and condemned the illegal act of the demolition of the mosque and also facilitate the construction of the temple and on the site where the mosque stood. By the way, the indemnification of the court ordered government to provide alternative site for the construction of the new mosque. And also there is a reconciliatory judgment, that even reconciliatory judgment which is constitutionally dissatisfying with fair enough to acknowledge the historical and political significance of the Act 1991, and also there is a constitutional significance of this act is the court have is intrinsically related to the obligation of a secular state and reflects the commitment of India and India to the equality of the religion. And also the court explained the parliament has mandated is no uncertain that history and wrong shall not be used as an instrument to appear as a present and the future. So there is a national finding in the Gyanvapi case, that is a contradiction. There is a sadly, it's a clear negation of this part of the judgment of the Gyanvapi Mosque Committee case 2023. The court permitted a survey in the mosque, and also there is a even legally sustainable findings in an otherwise unsecular judgment were negated by the court itself. It's a crucial point of time. So during this thing, the SAMBHAL case hearing, the Supreme Court was alerted about the orchestrated political move to breach parliamentary law in different parts of the country. The petitioner has stated several civil suits for pending in different trial courts challenging the origin on different mosques which are impermissible. Thus, the top court had an opportunity to decide the validity of the act and to adjudicate the matter. Finally, along the SAMBHAL case, it was only needed to reiterate, and also there's a large bench judgment in the Ayodhya case said about the Place of Worship Act that required to element of the judicial will. The speech bench hearing on the validity of the act offers the opportunity for the court to correct their own mistakes. Thank you so much.